Thank you everyone for being on the webinar. This is, to me, one of the most important webinars that I host throughout our process working together. We have Kathy Miller Ginsburg here today to share with us a lot of information that I feel parents want to get a head start on. And so I like having this meeting in the time frame that we're doing it before we do all the loan processing and so forth, because this is really give you something to really work out these forms with your student, get on the same page. Now that everybody's made their decision, it's go time. So I'm really excited for all of you crossing the finish line. It's exciting. And now it's funny because I tell families that, once your student goes off to college, the administrators of college doesn't care about parents anymore. It's just about the student. Like, they won't even listen to you because they're their own adult unless you have certain forms on file. And obviously you're paying for all the education, so you need to have access to these things too. So I'm gonna let Kathy take over and give us a full overview. At the end, we'll do a Q&A session. And then I do suggest that you follow up with Kathy afterwards if you have additional personal questions. And she does also do this as her profession. So you can definitely pick her brain, and she offers some time and advice. With that, thank you, Kathy, for sharing your information with us, and go ahead and take it away.
All right, so first I will introduce myself to you. Again, Kathy Miller Ginsburg. I'm a trust and estate attorney here in Westlake Village. My office is actually just off on Lindero Canyon Road. I've been practicing for about 25 years, and I primarily do trusts and estates. And part of what I do is I actually meet with a lot of college kids, or kids once they turn 18 years old. They don't even have to be going to college. And I usually do these documents, and for anyone who comes through Trevor, I do it for $200. They come in, I sit down with your child, I go through all the documents, we fill everything out. And at the end, you guys have the originals, and the child will have a copy of the ones that they think they should bring to school. You'll keep the other ones usually at home. Sometimes the kids will keep the originals, just depending on the facts and circumstances of the family. And in addition to this, I do trusts and estates. So I form living trusts all the times. I do trust administrations. I do conservatorships. I do guardianships, and anything kind of in the trusts and estate arena. So that is my practice. And again, I've been here for 25 years. I'm local in the community. I have a 29-year-old and who just had a baby. So I just became a grandparent. Oh my gosh, start all over again. I have an 18-year-old who is graduating college right now. And I have a 10th grader who is at Oak Park High. So I'm kind of local in the area. So these documents are really important because as a parent, you guys have all control over your kids until they turn 18 years old, and then you really have no more control over them. And the only way to help them or continue to even take care of them or do anything for them is to there's basically 3 important documents. And then there's kind of a 4th I'm going to throw in. But the first one is the Advanced Healthcare Directive. And that, I think, is the utmost important document that your child can complete. And I'm going to go through it. But in general, that's who can make healthcare decisions for your child.
Cool. We'll ask me to write a review for them.
Real quick, can I ask everyone to mute your microphone, please? Because we're getting feedback.
Yeah, and I'll answer at the end of this. I will take all questions until you guys are done asking me questions. So back to the Advanced Healthcare Directive is probably the most important document, because if something were to happen to your child and they can no longer make healthcare decisions for themselves, that can be a car accident, anything like that, then the doctors will look to an Advanced Healthcare Directive as to who they can talk to and request healthcare decision-making from them. So I do think this is the most important document. The second document is it's a Hipaa release, and that's basically a release of medical information. And again, that kind of goes hand in hand with the Advanced Healthcare Directive. They're kind of partner documents. The Advanced Healthcare Directive says who can make decisions, and the Hipaa the HIPAA release for medical records allows you to go to their doctors and actually get all the medical records. So if a child needed surgery and you needed your pediatrician records, you would technically need a HIPAA release to go get those pediatrician records. And then the last document that we'll talk about is a power of attorney for assets. And basically that document, once it's completed, the child can be giving the parent or whoever they want as their agent the ability to make financial decisions for them. And there's a whole list, and I'll go through the document with you of what types of financial decisions that you can possibly make for them. So I think in doing these seminars, I definitely have had parents come up, and the ones who have done them or have heard of stories, and the famous story is always, the kid goes away to college, they're back east at school, they get in a car accident, they're in the hospital, they're unconscious, and a parent calls the hospital to find out, what's going on with the child, and the doctor does not even have to speak to the parent unless there's some sort of healthcare directive that would allow the doctor to even speak with you. So as a parent being 3,000 miles away, how are you going to get on a plane and go out there and, even go to court and get some kind of emergency powers or anything like that? That would be way too hard to do when all you'd have to do is show this document, and it would give you all the power you need for the doctor to have communications with you about what to do for your child. So the first part of the document is where the child would designate, and these documents, by the way, work for parents too. I actually have a simpler document that I use for kids, and I have a little more in-depth document that I usually use for parents, and it includes, other kinds of wishes, like if I'm terminal, do I want some life-sustaining measures? Do I want CPR? Do I want, there's a place to say, I don't even want you to give me, a feeding tube. I'd rather die on my own accord. Those are kind of too much usually for kids. So I really have a simpler version that I use for the kids than I do for the adults. But the first part of it is part one. It's where the child will name the person who they want to ask for them. The child is the principal, and then the parent or whoever they name is the agent. And they basically write down the person's name, phone number, email, and all the contact information for reaching whoever their designated agent is. And on the form that I do, I have 3 places so I can have alternate agents. So sometimes a child might list one parent and then a second parent if they can't reach the first parent. Sometimes a child will want the parents to jointly make a decision. I find sometimes if there's a divorce, it's more common that a child might say, I want my parents to both make a decision as opposed to one or the other. And then sometimes a child will say, one parent's been around more just for medical procedures and things like that. So a child might pick one parent, and if that parent's not available, go to another parent. Some kids will even pick a sibling. But again, I leave room for 3 places. And if they really wanted more, they can put more in, they can put less in. But typically they put one, they usually put their parents, and then sometimes a sibling is what I typically see. I think only on 1 or 2 occasions have I ever seen a child list a friend over a parent or a relative. So that's part one. And then the second part is what's the authority? And this is kind of general information. For lack of a better word, I'd call it just the default language in an advanced directive. And it comes straight from the probate code. And that's where it says 1.2 agent's authority. And it basically, those are the things that the agent, you being the parent, can do for the child if they've signed this advanced healthcare directive. So it says, consent, refuse consent, or withdraw consent for any medical care service, tests, drugs, They can choose or reject a physician because, again, if the child's in back east, 3,000 miles away, you really might want your local physician who's known your child to have some input on what kind of care they're going to receive, even if they're having some sort of emergency surgery. And receiving consent to the release of the medical information from whatever procedures the doctor is doing for the child at that time. So that's kind of the general or boilerplate, whatever you want to call it, information that the agent can do on behalf of the principal. The next part is, when does the agent's authority become effective? So a child typically doesn't want the parent to make any decisions for them until they become incapacitated. And that's generally the decision that most kids make and even most parents make. On occasion, I will actually see a child or a very old person they might make the decision that they want someone else to make medical decisions for them, even though they're perfectly capable of making their own decisions, just because they either think I won't make a great decision, I'd rather someone else make that decision. But typically this authority does not become effective until there is an incapacity, meaning someone's unconscious, meaning they don't have the wherewithal that they can make any sort of decisions, and that's when it comes into play. And then, of course, the agents, again, the parents' obligation to act. The parents, would then be obligated to make healthcare decisions pretty much kind of in the best interest of their child, which most parents, I would say, are doing that anyhow, but that's kind of one of the obligations that's specifically listed out. And again, this kind of goes to, it's like the boilerplate language from the probate code, but you want to be making sure that you make decisions in the best interest of your child. An agent's authority for medical information just means that that's also a statutory provision. That's kind of where specifically you have a release that you can get or use any kind of information that you have from other medical records of the child for making your decisions. 1.6 is actually kind of sad. It's agent's post-death authority. That means in the event the principal, the child, or whoever's drafting or writing or signing the advance directive dies, the agent has the decision-making power to decide if there's going to be an autopsy, if there's not something in writing about, organ donation, the agent gets to make decisions about donating the child or whoever the principal is, their organs. They get to decide if they're going to be buried or cremated. All of those decisions are made by the agent on this advance directive. So that's a very important piece. Typically I find more kids don't think about that at all. So I sometimes will have them put in the sentence, leave that decision up to my agent, typically if that's their parent. More adults who come in have thought about that, and they will either say, I wish to be buried, I don't want to be buried, I wish to be cremated, I don't wish to be cremated, I want my ashes spread over the redwood forest, or whatever they want. And that's usually a place where I will have someone put some specific language into their post-death wishes. I don't ever want an autopsy unless that was murder. No, I don't ever want an autopsy, but those are the places you put that in. 1.7, which is on the top of page 2 here, is the nomination of conservator. So that would be the situation where a child maybe didn't have a good outcome from an accident, and now maybe they're never going to be able to care for themselves. In that case, you need to usually get a conservator for the child. And a conservator is kind of a court proceeding where the person who becomes the conservator kind of stands in the shoes of the conservatee and gets to make all those decisions as if they were that person. So what it is this advance directive is only coming into play if someone doesn't have capacity. But if that capacity becomes permanent, sometimes you'll go to court and you get a conservatorship that makes you kind of the permanent agent to act, and you have actually a paper called letters, and those letters give you the absolute authority to stand in the shoes of the conservatee and make all decisions for them regarding their health care. So there's conservatorships of both the person, which is healthcare decisions essentially, and the estate. And the estate is making decisions over any of their finances. So if it gets to a place where the child's never going to come back and be able to make those decisions, or whoever the principal is not going to ever be able to make those decisions anymore, then then you can get a full-on conservatorship. It's a court conservatorship, and the court kind of oversees the matter. A lot of times if there's no assets involved, they will just appoint you, and basically you fill out a form every other year, just kind of giving an update on what the conservatee is like. If they actually have assets, the court will actually monitor how those assets are spent, and you actually have to turn in an accounting every other year to the court, and the court actually reviews it and they make sure that the money is being spent appropriately. And so those are the reasons you may or may not want a conservatorship. Part 2 is instruction for healthcare. If anyone's been around a while, we used to have something in California called a living will. And the living will was simply, it was like a one-page document that said if you wanted to be kept on or taken off life supports. There was a case, I don't know, it's probably 30 years ago now. It was a woman named Ann Quinlan, and her family, she was brain dead, completely brain dead, but she was young, so her body was healthy, so she was on life supports. And her parents wanted to take her off life supports, and the doctors would not let her be taken off life support. So the parents, they spent years. I mean, I think it was something like 6, 8, 10 years. I don't know exactly how many years, but going to court to actually pull the plug for Ann Quinlan so that she could actually, die in peace. And because of that, this idea, this concept of a living will came to be, and pretty much the two decisions, it used to be much more harsh, like, take me off life supports if I'm a vegetable, and or let me live no matter what. And so those were kind of the two choices. And as time progressed, I'd say those two choices have become a little more colorful. They've added more words, and not to make it so harsh, like either alive or keep me alive for sure, or let me die for sure. And so now it's kind of, the living will is kind of morphed into this advanced directive, which was really 2 documents. Originally it was 2 documents. You had a power of attorney for healthcare, and you had a living will. So you had someone who can make healthcare decisions, and then you had the specific request if you were a vegetable. And then over time, it morphed into one document. So now it's the advanced healthcare directive. So now you designate who your agent's going to be in one part of it. And then in the next part 2, you say whether you want to be kept on or taken off life supports. So the decision, how it's kind of morphed to today, it says end of life decision. So now it says something to the effect of, I do not want my life prolonged if, 1, I have an incurable and an irreversible condition that will result in my death within a relatively short time. 2, I become unconscious, and to a reasonable degree of medical certainty, I will not regain consciousness. Or 3, the likely risks and burdens of treatment would outweigh the expected benefits. And so that's essentially you can pull the plug. And then the choice to prolong life says, I want my life to be prolonged as long as possible within the limits of generally accepted healthcare standards. So as you can see, it's kind of not so harsh of a decision right there. So then, that's the next thing to think of. So once you pick who you're doing, then you pick if you want to be kept on or taken off life support. Typically, when people ask me, one of the things I say, if you check the box not to prolong life, that allows your agent, the person who you designated to make decisions for you, the ability to say, it's okay if you take them off life supports because I know that's what they would have wanted. Whereas if the person, the principal, picks choice to prolong life, that does not give the agent any powers to ever pull the plug. So if someone really wants to leave that decision in the hands of the agent, then they really need to kind of pick the first one, because that gives the agent all powers to make the decision to take them off or not to take them off. Whereas again, if the principal picks number 2, the agent has no ability to actually take them off life supports, because they're kind of saying, I want to be kept on no matter what. So 2.2, relief from pain, that's pretty much just a direction. And I've never seen anyone say, please don't, give me any relief from pain. And that probably comes to, if you're really ill or anything, that you can get anything, morphine, whatever they need to help you feel better. And then there's a provision for other wishes. And I definitely have people who have very distinct wishes about what they want with respect to their health care. So you can either write it in. And when I meet with adults, or older than 18 adults who may be thinking of this as they age more, I actually have like a whole page and a half of kind of questions that someone might answer like what's important to you if you can't get out of the house. I always use the example of my husband because my husband's like a sports fiend. He watches sports all the time. He loves sports. And if my husband couldn't speak anymore and he was sitting in there and he wasn't brain dead, if he had a terrible disease like ALS or something like that, I would literally put him in front of a TV watching sports because that's what he would like to do. So I have a lot of those questions in for the adults. But if you put the sports on for me, I'd probably have to try to figure out a way to kill myself if I had to watch sports all day long, every day. Next is organ donation. A lot of kids and parents alike put on their license at the DMV whether they want to be organ donors. But also it's good to have it here because your agent's the one who's going to be with the doctor telling them what to do. So you can select either A, I don't want to give any organs. So you just put a big old X through this box, through this part 3, initial it, and you're done. You're not donating anything. And then the other option, you can check the first part that just says, I give anything that they might want. And then the second part, I actually just had someone today check the second box. They're only willing to give their kidney and liver. I don't know why, but they're like, I don't want to give my heart. I don't want to give my eyes. I don't want to give anything else, but my kidney and my liver, they can have. And the funny one that I had once is I had a client once who wanted to give their skull, just their skull. Like they wanted their skull to be given away. And that was, to me, always the most unusual donation that I've ever seen before. So then once you do give away your any of your body parts, it can be used for 4 different types of areas: therapy, education, transplant, or research. If you're up for all of them, you could circle them or just leave them as is. If you don't like them, you can cross out the ones that you don't want them to use your organs for. And then that's organ donation. And then if once you do that, the next part is your primary care physician. There's always a place for your doctor. That way, if the hospital has the advance directive, your doctor can be on there, the doctor can call, and that's always a good thing to put on. And then you sign the document, and the document needs to be witnessed by 2 people, or it needs to be notarized by a notary. And so when people come into my office, just so you know, I am a notary, so I usually just fill out the document with them, and then I notarize it, and then it's done. So why don't I open up questions for the advance directive before I go on to the other documents, because I know there's usually questions on this one.
Yeah, at this point, if there are any questions, feel free to chime in. That was a lot of info that was covered. A little
overwhelming.
Overwhelming, yeah. A lot of legal.
So once you have the form signed by 2 people, you just hold on to it, and if your kid is ever in the hospital, you show up with the advanced healthcare directive in hand?
You can do that. I would recommend, you can, a lot of hospitals where you are locally, they can scan them. Sometimes they can scan them into their system. Like, my mom's at Kaiser, her advanced directives is scanned in at Kaiser. You can give it to your primary care physician. If a child's going to be at school, and I will find out this year because my daughter has her advanced directive, the school actually scan it in for their, I don't know if for their hospitals or not. I don't know the answer to that. And I don't know if different schools are different because maybe a big school wouldn't, but a small school would.
I think there's different directives for different states. If you currently live in California and your kid's going to school in another state, do you do the California one?
I always do the California one because the kids are still residences here. It's just, and they're not going to say we're not going to speak to you because it's a California directive. If your kid was going to maybe stay in another state permanently, then maybe you'd want to do it there. But I would always do this and then you redo it. This truthfully is the document you'll redo the most in your life because they always want to know that this is current. So whereas you do a trust, you may not make any changes for 15 years to it. But if you have an advanced directive, you really want to, as things change, you want to make sure you have up-to-date wishes, on file. But like I said, what I have the kids that come to me do, I usually have the parents keep the original. I have the kids bring the advanced directive to college. And I usually tell them to make sure their roommates know. You stick it in an envelope and it says advanced directive, and and you tell the roommate, if something happens, bring this to the hospital, because usually the roommates even hear before the parents, what happened. And they can usually, they're right there and they can bring it over. But yeah, they can take a fax copy too. So if you know your child's at a hospital in Boston, you can fax it over to them, and then they would accept that. Or I've never seen them not accept it, I should say.
Thank you.
Any other questions? All right, so I will go on to the next document. And the next document is, it's the Hipaa release. So this is the document that I have the kids fill out. And this is even different than the ones I use for the people who come in for my estate plan. It authorizes the parent or whoever they want to authorize access to their protected health information. And then what I like about this one is I put on a period of time. It can be all periods of time, or sometimes kids just want to limit it to college period. They might limit it to 4 years or something like that. So it gives them a little bit of power to limit when you can get access to those medical records. Number 3, the extent of the authorization. It's funny, it's a little tricky. So this, you can authorize them to get all your records, including, drug and alcohol, HIV, those records, or I allow the kids to exclude those particular things. So they can either give all records, or they can exclude mental health records, or they can exclude, HIV and AIDS or communicable diseases. That way they can feel like, if they're doing something, they want their parents to be there, but not 100% there for things like, if they have some communicable disease. So it gives them a little power on this document. I don't have anything on like this on the one I usually do for the parents. And then the metal for
real quick.
Yeah.
Do you have the other form that you can put up?
The one that I use for the parents? It pretty much it says the same thing. It just doesn't has a date on it. It doesn't have a date and a limiting date, and it doesn't say exclude my HIV and AIDS and communicable diseases information. It's just drafted a little different for adults versus just a kid. This way it gives the kid the power to say, I want my parents to have all information, or just exclude a few little pieces of it.
Okay, got it. Because we had a question. I didn't know if there's a different form that you wanted to show other than the.
Because this one's really for the college kid 18 one.
Got it.
I have that one that I do in my estate plan for the adults, which, like I said, it's really not any different. It just gives a little more power to the kids. And, I find most of my trust clients aren't thinking about HIV and AIDS and communicable diseases and withholding that information as much. Or even mental health information from their spouses and things like that. Whereas kids are in college, that's kind of where some of that happens. So it's a little designated, cut out. But they can, like I said, they can leave all of it or not. Medical information, just that the parent or whoever the person is can have access to all of that. And then it says it can be revoked. And that's really it. It's basically just saying basically all this says is you can have my medical records, and it's which medical records can you have? Can you have all of them, or can you only have, certain ones? Can you have everything, or everything but alcohol, everything but mental health? And then that's pretty it. And then there's a period of time on this, and it can be all periods of time, or it can be limited. And that's the only difference on this document. So, but it's really a very simple document. Any questions on this one? This one's pretty much like when you go to your doctor and you sign that release, they always have you sign something when you go into the doctor, and it's their medical records and things like that. That's usually what you're signing off on, so that they can have access to medical records.
Sorry,
all right,
me, but are you actually showing that form? Because I guess I'm still seeing the Advanced Healthcare Directive.
Oh, you don't.
I'm still seeing the Advanced Healthcare Directive as well.
Oh, I'm so sorry. Okay, now it's on my screen. It should say Hipaa Privacy Authorization Form. You guys don't see that?
Mm-mm.
All right, let me see if I have to click something else again. Oh, that's so, I'm sorry. I think I clicked to it and it didn't go. All right, here. Did that work?
There it is.
Oh, sorry about that.
No problem.
All right, so let me go back real quick on the form. That's why you're asking me if I have a different form. I thought you were asking for the other two forms. No. All right, so this is the HIPAA privacy authorization form. So one, just briefly again, and again, really the whole point of this document is, can you get access to medical records? So one just says who can get access. Again, kids name parents. Two, what's the period of time that they can get access? And the period of time will say, you know, all periods of time or limited to these periods of time. And I definitely have had kids that limit it to like their 4 years until like 2025 or something like that. And then the third part is the extent of authorization. And again, that's the one that says, you know, can you have access to all my medical records or should something be excluded? And I pretty much have two little boxes that says you can exclude mental health, communicable disease, HIV records, and you can, and treatment of drugs and alcohol. You know, I have those little boxes that they can do. And that's pretty much it. And then basically it just says the person whose name can have access to my medical information and I can revoke this at any time. And that's really it. It's very, like I said, it's a very simple document. It's just who can get access to kind of medical records. And that's really the whole purpose of this. So let's see. So now any more questions? That's a pretty easy one. So the next one is, which is a little longer now, power of attorney, share. It's so funny, I must not have hit share when I did it last time. The power, you guys see the new one?
Yes.
Okay. Okay, so this is so the Advanced Healthcare Directive, like I said, the probate code it's kind of a standard document, and then lawyers, we doctor them up to, you know, based on what we think our clients need. So this is a lot of this, again, is kind of statutory. It's based on information in the probate code. But basically it says the principal, again, that would be the child, can appoint agent, that would typically be the parent, to help me with these particular powers, have these particular powers. And the first one is, can the parent, you know, if they initial by A, it means they can help them with real property transfers. Let's say a child does own a piece of property, you know, and the parent's here and they're selling it. You know, the parent they technically could use this form. I mean, in this day and age, they're going to use DocuSign, or they're going to send the form and email it and overnight it. But the parent could actually sign on the real estate deed, you know, sign for the child by parent power of attorney. And that would allow them to sign on a real estate document. If the child's incapacitated, right, they're in that car accident and they're selling that piece of property and they need to finish the sale, the parent can actually sign on the document using this power of attorney, and they just sign for the child this power of attorney. So it does have like some broad uses there. It doesn't apply to most 18-year-olds, but it is there. Next is tangible personal property, you know, transactions. That's selling a car, really. I mean, it can be anything that's tangible personal property, but the most common one that we would see is, can the parents go to the DMV, sell their car? Kids doesn't take a car to college. It's in the child's name. Parents want to sell it. They could actually use this power of attorney to, you know, to sell the car. However, truthfully, the DMV really is so lenient about, you know, signatures on pink slips, that I've seen people just sign it anyhow. Not that I would recommend that, but you could use the power of attorney and sign for the child to actually sell a car. C, stocks and bond transactions. If a child has a stock account or an E-Trade account or something like that, this kind of gives the parent the power to go make some, you know, transactions. They need to sell some stock so they can pay for college. So it would be there. Commodities and options. Again, most 18-year-olds aren't dealing with commodities and options, but again, they can give the parents the power to do that. Banking and other financial institutions. You can go into the bank and deal with their checking account, their savings account, or whatnot. Business operations, same thing. Most 18-year-olds don't have businesses, but there are definitely a few out there that do. And this would give the parents the power to stand in the shoes of the sole proprietor child to actually transact some of their business. Maybe they have Shopify accounts or whatever it is, although that's online. Again, they wouldn't really know that the child wasn't doing it, and the child could probably do it from wherever they're at. But again, you could do business operations for them. Insurance and annuity transactions. If you needed to change a beneficiary on an account, that using this power of attorney, you can stand in the shoes of the owner of the account and actually change a beneficiary. Estate, trust, and other beneficiary transactions. So same thing. Most trusts, so this is kind of like a tricky one. Most people who have revocable trusts, in the trusts, it'll say you can't use a power of attorney to change the trust. But if absent that language, you can use a power of attorney to change a trust, because you get to essentially stand in the shoes of the person who would have the power to do it. So you can see there could be a conflict there. So you really want to make sure when you're drafting your estate plans that if a power of attorney can change provisions of a trust, or if only the settlors can change the provisions of a trust. Most kids don't have a trust. Some do, but very few of them do. But again, they can allow you to make changes to their trust if they need to. Claims and litigations, those would be any kind of lawsuits or things like that. Personal and family maintenance, that comes into play if there's kids involved, and dealing with child and child support and things like that. Benefits from Social Security. So Social Security is actually fairly decent. You can have a designated payee with the Social Security benefits. Some kids get either disability, or sometimes if they have a deceased parent, they're getting some benefits. But this would allow you to stand in the shoes of the child getting those benefits. Retirement plan transactions. Again, if a child has an IRA or a Roth, or you can have actually custodian. You can have custodian Roth accounts, which I actually always think is such a great idea. Get your kids going in retirement with a Roth, where the money all comes out tax-free when they retire, and you can set it up, when they're young, and as long as they do babysitting, you can put that money into it, and now they're saving for their retirement. And then tax matters, if they're ever getting audited or anything like that. Or you can initial line N, and that's all powers. That means that they give, usually the child giving the parent all powers to act. So that's what I see a lot of times with husbands and wives, children and parents. Where I see it limited is if they're giving it to a sibling or a friend, then they'll really limit the powers. And then there's a place where you can list any kind of, special instructions. There's usually not that many that I see, but on occasion I'll do it like, I only give you the power to sell this one piece of property for us because I'm living in France for a year. So that's where sometimes you'll have some special instructions. Another thing, again, sometimes the kids will name one parent, and then if that parent can't do it, they'll have another one. And sometimes they'll want their parents to do it jointly. And on this document too, you can do either or, which I don't know if I mentioned that on the advanced directive, but you can say, I want my mom or my dad, which means whoever they reach, they would talk to. Or if you have the word and between it, like mom and dad, that means mom and dad must do it together. So the or means it can be one or the other. The and means it's mom and dad. Or you can list, mom first, or you can list dad first, and then you can list other parent second, or sibling, or friend, or whoever you want, or however you want to do it. Next, is this a durable or springing power of attorney? The difference between durable, it means it's right now. Durable means it exists as soon as you sign it. So if I sign a power of attorney naming Trevor as my agent, Trevor can essentially stand in my shoes, and he can go do all the transactions that I've given him the power to do today, even though I have capacity. Springing power of attorney means I'm giving Trevor the power to act for me only in the event of my incapacity. So if I'm in an accident or something like that, then I want Trevor to say, hey, I can take care of these things now. So typically I recommend, obviously with the kids, it's durable, meaning it's immediate. And then I think I just talked about acting jointly or separately or independently. You know, a lot of times I find with parents, either they'll do or like mom or dad or parent or so-and-so. Sometimes there's one parent who deals much more with the finances than the other. And I will see the kid pick that parent to make the financial decisions. They're like, this parent, my mom never makes financial decisions, so she shouldn't now. Or my dad never makes financial decisions, so he shouldn't. And so I see that. And then the document gets signed and notarized, and that's it. And then you have that document available. What I have found is like a lot of banks and some brokerage houses, they have had their legal departments, like I said, the lawyers get the statutory language and then they like to draft their own stuff. So I've seen like banks and I've seen some financial institutions actually have special language in there so they want you to sign their power of attorney, even though there exists, even though they have one that already exists that was signed. You know, the only time you would like have to use this, so you can sign more than one of these with different institutions if they need it for their particular purpose. But this is, like I said, it's a sufficient document. It meets the probate code standards and it should do everything that you need it to do. You can even use this form to fill out, you know, the jury. If the kids get jury duty while they're gone, you know, you can use this to fill it out to say they're at school and whatnot. All right, so any questions on this document? No questions. You know, the one thing, I get so many more questions when it's live, because I always feel like everyone's looking through, and I think I answer questions as I go, whereas on Zoom, it's easier to, I guess, do the whole spiel before.
It was actually super thorough and you went line by line, so I think you answered quite a few questions, but let's keep it open.
Once you execute a document like this, how does a kid then undo it when they want to be responsible for themselves?
Well, so they are responsible for themselves. You can take this. Sorry, they're taking I'm at my office. Thank you. So you can revoke it. It's called revoking it, and all these documents can be revoked at any time. And you can revoke it by putting a line through it and write, I revoke this. You can rip it up and do that. You know, the one thing that is potentially an issue is, say your kid gave it to someone and didn't know who had it anymore, because usually if you revoke it, you want to let whoever has it know. So that's why, like, I'm not always a big fan of giving it out, like use it when you need it and then not put it on file. The only one I would maybe put on file would be the advanced directive. You know, if it was my kid and they were at school and I know there was a hospital that they would be going to, thank you. And I knew there was a hospital that they would be going to, I might try to do that, but I would never use the power of attorney. I would just keep in my possession until I needed it to do something. And then if the kid wanted to revoke it, really, they should just take the document, they can rip it up, and now you don't have the availability of it. But, you know, there always can be a problem that someone has like a copy and they're relying on a copy, but they're not supposed to do that if it's revoked.
So, like in the case, if you tell a brokerage house, I have the power to act in my kid's behalf, here's a copy of this form, how do they then get notified that you're no longer
able? So you have to notify them. So typically, if you're on a brokerage house, you contact the brokerage house and you say, look, I'm going to be away in college. I want my mom to be on my brokerage account as power of attorney. They actually put them on. They actually input it into their system, and it'll say child's name and it'll say mom's name, power of attorney, right? And it's on there for good until it's revoked. So to revoke it, child's going to have to call up and say, get rid of the power of attorney. I don't want her as my power of attorney anymore.
Got it. Thank you.
And using the power of attorneys, people do that, especially like when people age, they might want someone else on an account with them. Not even aging, sometimes they just want someone else to take care of things. So you put someone on as a power of attorney. So I might, be married, have my thing, but I might want Trevor to make my investing decisions. So I might actually have Trevor, because I love how he invests. I actually might have an account that I put Trevor on as my power of attorney, and he could actually make all my transactions. He could do all my buys and all my sells until I take him off.
I wouldn't do that.
You decline. You would decline to act.
Decline.
Kathy, I had a question. For forms 1 and 2 that you've discussed, how typical is it to have to see an attorney to do those? Are those 2 forms, like the Hipaa and the Advanced Healthcare Directive, forms that the school should have that would they supply them to us?
School will never supply them to you. There are definitely forms online, but I have to be honest with you. The kids, when they're signing it, have no idea what they're doing. So what I do for everybody who comes in through Trevor, like I said, it's $200 and ends up being about 30 to 45 minutes. I sit down with the kids and I actually go over kind of what I did with you. So they are informed about what they're signing, because my only one thing is about taking off any document off the internet. People don't really understand necessarily the document and they're just signing it. And kids typically will just sign what their parents say. But I personally think it's super important for the kids to really they're adults. They need to start understanding what they're signing and what they're doing. You can't just sign stuff blindly. So that's the reason I do it. And like I said, I have my form that I use. But it's really not even the form as much as the time to explain what all this means and what they're doing with it and how important it is for them to start thinking of these things. So to me, that ends up being really where the attorney time comes in versus, but you're correct. There's tons of these forms, I'm sure, floating online in a lot of places, but the schools definitely don't provide them. I'm going to put up one more little form. It's the only form that I actually think the schools do provide. It's kind of the release. You can get access to your kids' transcripts and or payments when you need to make the payments. So you can actually go pay the bills online. There's a release that kids have to actually allow you to get in to do that. And there's a form online that you can do, but almost every school, actually, I'd probably venture to say every school has their own that they make you sign.
Okay, thank you.
Actually, I'll pull that one up real quick just so you can see it. This is like a generic one that I pulled offline because I never fill these out, but I wanted it for for the meeting so you can see. But this is essentially what it is. It's the FERPA form and it's the consent to release student information. So this is a form literally that I pulled online because this is the code section and it says what kind of records you can get. But every school actually has their own form that you sign that your child will allow you to be able to, pay their bills or see their records, and they have their own form for this. But this is this is the generic form that I pulled offline.
Can I ask you, I actually did ask the school for my son about that, and I've been given the access to pay his bills, but there was nothing that I could do to have access to his grades. So they were very specific, and I forgot the term, but I have, this access granted that I can go online and I can see what his charges are, but they had nothing grades for me to actually look at his grades. So I thought that was a little.
So, this form here, I would venture to say, and I haven't actually done this with anybody yet, but I'd actually venture to say, if the student's signing this off, that you should be able to have access to their transcripts and things like that if they would sign off on it.
The form says right there, transcript.
Yeah. So this one I pulled offline, right? I just pulled this from the internet, because like I said, I don't typically do these FERPA forms. I just usually do the other 3 documents, but this kind of goes in the conversation. And I know that when you signed up to pay your kid's bills, your kid had to allow you to get online to do it, which is kind of funny, but they do, even though you're paying for it. But I think it was my understanding before, and I don't know, Trevor might be able to help me with this one. I don't know if you've ever seen it. Maybe I'll do a little research into it to see to see how it would possibly work differently. Because, you do want to be able to have access to their grades, because you definitely hear the kid who's getting college paid for, but he dropped 3 of his 4 classes and he's taking only 1, right? And I've definitely seen that kid.
Yeah, exactly. Well, I will contact his college again tomorrow with this new knowledge too, and find out if they, I was talking to somebody who was not informed.
Write down the word on top, FERPA, consent. And then in the very first line on this form here, that's the code section that should allow you to get into it. And if you maybe throw the code section, maybe they're going to throw you to someone who's familiar with it. And maybe you'll be able to get access. Although, can't you just, I guess, log in on your child's account? They make it harder to do it because they do like a 2.
No, it's a duo, and it's only
Right.
on his phone. So yes, I can if I talk to him and say, give me your code.
Give me the code.
But I won't necessarily always be able to do that, and he might not
Right.
want to at a certain point. But yeah,
Right.
I know they make it a duo thing now. So
Yeah, that was pretty brilliant, truthfully, on the school's part, right? Get the parents out. I mean, I know they say it's the 2-factor authorization or authentication that makes it safer, which it probably does. But
Real
Yeah,
quick, one of my families mentioned that her older son does attend a UC school, and they keep the transcript different and separate from the payment FERPA form. So you might have to just inquire with the school to see which forms you need regarding that FERPA to have the release authorization. And then Kathy, the other one, there's a question about, are the rules different if the student is not 18 as of the first day of college?
so when you're not 18, technically parents get to make all the decisions, right? For all those documents, you still get to make them all, even if you're in college. I think the FERPA there might be a little more gray area because they're enrolled in school. But I think before they're 18, you can make all medical decisions. You can get all medical records, and kids can't contract, so they can't even open up a brokerage account or a stock account. You have to have a parent on as a custodian. Oh, and that's another thing, by the way. If your kids haven't turned 18, and you think your kids may not be as responsible with money and they've got some custodian account, if you go into the institution before they turn 18, under California law, you can have it till age 25, but they have to put it on the account, because if it's not on the account, the default age is 18. Kids get 100% access to custodian accounts at age 18. But if you want to, do it like I did it with all my kids, and my kids aren't even irresponsible, but I'm like, they don't need the access to any of their funds until they're 25.
I tried that with 2 of the custodial accounts, and neither of them would change it.
Before they were 18?
Yeah, they said you had to have set it up that way or you had to have changed it within a month of opening up the account.
Then you just open a new account. Then you say, okay, close this account and open a new account until age 25. That's not correct, and there's a way to fix that. You absolutely have 100%. You could sell everything tomorrow before they're 18.
So you just made Kathy mad.
Well, yeah, I would be fuming if they said that to me. I would be so mad. I would be fuming. I would probably move my money out of the institution. I'd be so angry if they said that to me. But yeah, I would close the account and open a new account. Say, okay, close the account and open and transfer the money to a new account.
Yeah, then you got to pay capital gains on all that.
No, I didn't say sell everything. Just move it to a new account. You can do stock transfer over. There's no capital gains on that. And some other institution will be more than happy to take your money, I'm sure. They just do a transfer. So they transfer whatever exact stocks and things like that you have over to the new institution. You're not selling them. You're just moving a new accounts, and just do it before they turn 18, and make sure you put on that it needs to be to age 25.
Yeah, and you can do that not only with bank account, but even retirement accounts. If you have IRA or Roth for your kids, you can do that too.
And I recommend it, unless the kids really made all the money on their own and they're doing, a lot of times they're getting money from, I don't care what it is, holidays, presents, things like that. That's some of their money, gifts from grandparents, parents. whoever it is, maybe it's some little job money, but, usually I'd say, 80% of the time, 90% of the time, if you can keep the control till 25, then they're out of school, it all goes to them and they're fine. But yeah, any custodial account.
So I have a follow-up question on this child not turning 18 on the first day of college.
Yeah.
Any forms that we sign then, are they valid throughout the year? Because within that year, they're going to turn 18 for sure.
Yeah. So typically in contract law, if you sign before you have the ability to sign, it's voidable by the kid, meaning they can cancel it until they turn into 18. And then once they turn 18, then it's valid at 18, but it's voidable beforehand. Right? So they can void it, or right when they turn 18, they can void it. So
but if they don't, does it continue as a valid document throughout the year?
It becomes a valid document. It's a valid document. It's just a voidable. It can be voided, but it's valid until voided. And usually what I'll do, I've had some kids come in, they are not 18 when they leave for school. We sign all the documents. And then when they come back for break or at the end of the year, I just reprint them out again because I don't really need to go through them again. And then they just re-execute with the new date once they've turned 18. And I've done that for a few kids that I've had, and I don't charge anything extra for that. They just come in and sign again.
And are these documents to be signed every year, or is it?
No. They just do them the one time, and they're good until they're revoked. And when they're revoked, you either revoke them by ripping them up, writing I revoke, and then making sure you contact anybody who's relying on the document, like the power of attorney. If you're on the account, you need to take the power of attorney off.
Yeah. So I'm surprised that colleges are not actually reaching out to us with these forms, at least not the college my kid is going to. So I wonder if this is not signed, they're not 18, God forbid something happens to them, who is the deciding authority for their specifically for the medical situation?
The doctors make they make the decisions just based on whatever they have. They don't have to listen to anybody, right? They don't have to follow anybody. If there was something really controversial, but they get to, there's laws that the doctors can make decisions based on what they think is right, in emergency situations.
Okay.
And anything really not emergencies, they're not going to really do anything unless someone goes to court. And then they even have what's called public administrators. So if no one does something, but there's something that needs to be done and the doctor can't make the decision because it's like not an emergency, a public administrator can apply to the court to get a conservatorship over the person so that the public administrator can make the decisions for the person. And that's what happens if it's a permanent matter. That's not like an emergency. If it's an emergency, the doctor is going to just do whatever they think they need to do without anyone's input. If it's not an emergency, but it's a long time thing and someone doesn't come get involved and apply to the court to become the conservator, a public guardian will apply to the court to become the conservator. But then,
before all of that happens, they'll try to contact the parents, right?
Well, they usually they'll want someone to go to court to get a conservatorship over the child, right? If there's no documents, if the child didn't sign any documents, and it's no longer an emergency, but they're going to be in some sort of assisted living for a year because of whatever happened. They want someone to make these decisions for them. So either, then they might reach out to the parent to apply to the court to get a conservatorship over the child. So then you get a court-ordered conservatorship. Because remember, I was talking, if you have a conservatorship, that also allows you to govern what your kid's going to do, the medical decisions. And if a parent didn't do it, then the public guardian does it. But assuming the parent goes to court, but then you're paying, right? You're paying for a conservatorship to go to court. Whereas if you just had that advance directive, and at least you can start making all those decisions without having to go to court to get a conservatorship over the child.
No, I understand. I'm just wondering why our college is not actually sending it out. Is it just me, or they generally don't send this out?
They do not send them out.
Oh, okay.
I've never seen a college send them out. I don't know if Trevor has.
I'm going to ask for a special request just because I love this person. Stacy, do you mind just mentioning what you wrote real quick? Because I'd love for you to just share that experience during the parent orientation.
Certainly. Here, I'll even. Okay. I went to parent orientation at UC Davis 3 years ago, and we had a mess of speakers, and the guy in charge of SHIP, which is Student Health Insurance Plan, and other health related things, he basically said, parents, you don't want the Hipaa Release, do not sign that. And the parents were like, some of them were aghast, and they were like, what? We want to know when our child goes to the doctor. And he said, no, you don't. And he said, I just put a kid in college, trust me. And he talked about it, the healthcare directive, as separate from the Hipaa Release. And he said, your kids don't want you to know when they get contraception or what have you. And it's their right to have privacy. So he just dissuaded us from that. Then in the same speech, he talked about FERPA as well. And he said, you let them have their privacy. He was very funny. He said, you can find out their grades in very sneaky ways, like say, oh, for the car insurance, I need to get the transcripts so that I can get the good student driver discount. So please send me your transcripts. And that's how you can access them without making your kids feel like you're hovering over them. And so I thought that was kind of genius, and it does work. And my son, he could release he could turn over the power to me so that I could pay the university without releasing everything else. I suppose they were kind of separate pieces. And I happen to trust my kid, and we have a relationship that's pretty solid. So it worked out okay. And I assume the same for my daughter when she goes off in the fall. But I thought that was interesting that the university said, don't stay away from your kids' private lives. And so some of the parents were really incensed.
So to be honest with you, like I said, on my HIPAA that I have for the kids, that's why I actually have a place that the kids can cut out, like I said, those certain items, because I do think too, drug and alcohol, if they're getting, they do something stupid or whatever, and, you're right, contraceptives, communicable diseases, they can actually allow for, sometimes they'll go to school and kids will have depression and things like that, and the parents really want to still be involved, but they don't need to know, you're right, who they're sleeping with. So that's why I literally have the boxes on my form that the kids can cut out those particular items. And a lot of kids take that up, right? Because they think, they're like, oh, I'm going to be in college. Oh, I'm going to be drinking. Oh, I'm going to be doing these things. So they actually don't include those particular items, but they include everything else. And that's why I revised my HIPAA for the 18-year-olds. That's totally different than the ones I have for the parents, the adults, estate planning clients and things like that. But I don't disagree with what Stacy just said. I think that's true. I mean, I think sometimes kids are even hesitant to give that right just because they're thinking that, but when they have a place they can cross it out that there's some rights they don't have. And and like I said, and I think different parents do different things about wanting to know the grades, because I've definitely seen the kid who drops 3 classes, 3 of their 4 classes, and then just goes and the parents don't even know. And then all of a sudden, after it's 3 years later and they have hardly any units and they've been paying for school for 3 years. But that's not every kid. I mean, your own kid, and you've got to decide what you've got to do for your own child. But I liked what she said about that. And the advanced directive, you definitely want that. I mean, you definitely want to be able to make medical decisions if they can't. And it is, like I said, there's 2 different documents for that reason.
I hope that this was informative. I know that some of this information could get a little dense, but this is important. I'm really happy that all of you had the time to join us for it. Definitely follow up with Kathy if you have some questions. She's a wealth of knowledge and she's helped us out for a few years now. So I'm thankful for you, Kathy, for doing that.
Thank you.
We'll be in touch for our next webinar, which is going over the loans and how to get those dispersed. That'll be in June. Have a great evening, everyone.
Thanks, Trevor.
Got it.
Thanks. Have a nice evening.
You too.
Bye, everybody.
Thank you.
Bye.